This is case 2356562, the people of the state of Michigan versus Michael Raymond. Mr. Raymond is charged with 1 count of assault with a dangerous weapon, felonious assault, set for an exam today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
May it please the report for the record, I'm Attorney James L. Galen, Galen Jr., P43406, retained counsel on behalf of Michael Raymond. Mr. Raymond, can you come up here, friend? Is it okay if you adjust the court from your justice?
Yes, that's fine.
State your name for the record.
Michael Aaron Raymond.
Good morning. Are the people ready to proceed?
Your Honor, the people at this time are asking the court for an adjournment. My apologies for the last minute request. However, that's why I stepped outside. Speaking to the OIC, which is Officer Rumschuck, speaking to the OIC, it has been brought to my attention that subpoena was not served to the civilian, the necessary witness in this case. Normally, subpoenas were sent out to the officer in charge due to the new system, and this actually only being her second case with the new system as an OIC. She was not aware that she has to manually download that, so she only saw hers and left it at that. Officer Rumschuck, do you mind state your name for the record?
Yes, Officer Rumschuck.
And could you please explain to the court, I know I just started saying it, but in your own words, whether or not the civilian complainant was served, and if so or if not, why?
The complainant was not served of the subpoena because I am unfamiliar with the system still. I'm still learning it. I was unaware of downloading myself.
Unless your honor is considering entertaining an adjournment, I'd ask for a dismissal without prejudice. If you want, they can always reauthorize at a later date. Today's date and time for preliminary examination. Proper service of the subpoena is either hand delivery to the individual that you're subpoenaing to court. It's supposed to be done within 48 hours prior to the court time. Witness fee is supposed to be delivered to that individual along with the subpoena. And it also can be delivered certified mail restricted delivery. But today's date and time, it appears that no efforts have been made on the part of the prosecution or the officer in charge to personally hand deliver a subpoena to the complaining witness. So with respectfully requesting dismissal without prejudice, your honor. If you feel strongly enough about it, you can always reauthorize.
And your honor, and I know that this is not part of that. The people do believe these are serious charges that should be heard during a preliminary exam. But after speaking to defense, it also has been brought to our attention that they're not made or have not viewed or seen, or possibly there is called in question. On our end, it appears that it was sent to them, the video discovery of the actual incident. If defense indicates that they do not have it, we'd also like an opportunity for defense to review that video that we believe is extremely important. We were actually going to play it today during the preliminary exam. As the court knows, we don't often play video. That is how important this video is, so we believe defense should view this video. However, if the adjournment is not granted, we believe that there's good cause to do so, but if the adjournment is not granted as defense, that we have to reissue it later.
And your honor.
No need. I'm going to dismiss without prejudice.
Thank you very much.
Your honor.
This is not a case where the officer in charge was lazy, didn't do her job, or any ill intent. However, the witnesses are not here because they were not subpoenaed. Today is the date set for the exam, and that date is set for a while now. We set on May 30th.
And just for the record, it is approximately 9:30, somewhere, 9:30 on the spot right now.
Dismiss without prejudice, as Mr. Raymond, as your attorney stated, police may reissue this case, okay? But at this time, your case is dismissed.
Do we have an order form that I can fill out, Judge?
Yeah.
Thank you, Ron.
I will bring it out to you guys. Okay, thank you, sir.
Please do. Please do.
Mr. Raymond? Attorney Dox, good morning.
Good morning, Your Honor.
Did you get the email from Ms. Parrish?
Oh, she.
Yes.
Yes, I'm sorry, Your Honor, I cut you off. Yes, I did. This morning, I was in trial and the jury deliberated a little bit later than we thought. So, but we're going to grant the people their adjournment, Your Honor. So we're not going to object.
Okay. All right. Do you have it, Mr. Carter? I have the date. Do you know what date? I think after 26 is what Parrish said. For a good date.
Yes, so the officer in charge returns furlough.
Yes. Okay. Ms. Glenn,
Yes.
want to come in the courtroom?
Huh?
You want to come in the courtroom or do you want to stay in the hallway?
Whatever you need me to do.
You can stay right there.
Okay.
All right. This is case 2357023, the people of the state of Michigan versus Adriana Glenn. Ms. Glenn is charged with 1 count of home invasion first degree, set for an exam today at 9 o'clock. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor, and Your Honorable Staff. Attorney Quentin Dox, P number 79657. On behalf of my client, Ms. Adriana Glenn. Ms. Glenn, please state your full name for the record.
Adriana Glenn.
Attorney Dox, Ms. Parrish sent an email yesterday requesting an adjournment due to the officer in charge having some issues with subpoenaing the complainant and the witness through their new PBK system. Did you see that email?
Yes, I did, Your Honor.
Okay. Any objection to the adjournment? I didn't hear anything you said.
And all that. So we're going to, no objection, Your Honor.
Okay. All right. So let's get a date here. Can you do July 5th or July 3rd?
That's right before July 4th, Your Honor, as you probably know.
Yeah. And I'll be here. You be out of town somewhere enjoying yourself.
Can we do like July 6th?
Oh, let's see.
July 5th.
July 5th or 6th works for the defense, Your Honor.
Okay. So July 5th, we can do 10:30 or July 6th, 9:30.
July 6th.
Okay, you are Kalana, July 6th will be fine. Thank you, appreciate you.
At 9:30.
At 9:30.
Okay, so Ms. Glenn, you got that date?
Yes, I do.
Okay, all right, thank you all. I'm sure the people appreciate it. I'll
Thank
see
you all.
all then.
All right, thank you.
Ms. Glenn, you're all set.
You all said, Ms.
Thank you.
Ms. Glenn,
Yes.
need any paperwork for work today?
Yes, I do have paperwork from work.
No, I'm saying, do you need anything to provide to your job that you were at court today?
Huh?
You need paperwork showing that you were in court today for your job.
Oh, yes, yes, I do. But I told my manager yesterday, so he knows. That's why he gave me a different time to come in.
Do you want some paperwork to bring back to your job from today?
No, no, thank you.
All right, you're all set then, Ms. Glenn. Have a good day.
Thank you.
Oh, thank you. Attorney Jefferson?
Good morning.
Good morning. Are you here for Darnell Allen?
Two things.
Okay, let me call this dismissal. And I'm gonna put this dismissal on the record and then I will address your case, okay?
Okay, thank you.
All right, this case 1657408, from the state of Michigan versus Jamez Farmer. Mr. Farmer is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, delivery, manufacture, marijuana. Count 3, weapons, of firearm. Set for an exam today. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of people, P 85495.
Morning, Judge. Jeff Perlman, on behalf of Mr. Farmer, P 80517.
Mr. Farmer, please state your full name for the record, please.
Wrong Farmer.
Good morning. Chief, ready to proceed?
Your Honor, my apologies. At this time, people aren't able to proceed. One of our necessary witnesses is no longer with the department. Reevaluate.
That's my defense is ready to proceed.
Okay, I will dismiss without prejudice, as people are not ready to move forward. I have the order of dismissal signed. Should take
Good day.
you as well.
You don't have a tether.
No, ma'am.
Okay.
How many judges?
Is anything better? Not the time.
I heard CPL.
Yeah, my client has a question.
You wanna go?
May I approach?
Ms. Parrish. You well, sir, on Mr. Farmer, want to CPL, you stated, do you have any information on how that works with the case dismissed based off of?
For which thing? I'm sorry,
Mr.
Jan
Farmer.
Roach?
Mr. Farmer, what the CPL would say.
I don't know, because, yeah, I don't know, but if it's an order, I need to sign. You know, the process, I sign.
You're also in charge, right?
You can ask him on the hallway. He might.
All right,
If he
appreciate it.
doesn't, he doesn't. He's a helpful gentleman. He might help you out. Thank you again.
Yeah, okay.
Mark, Dow, I didn't see you.
Ready, Your Honor, my client's outside.
We just went out there real quick. I had a question on that one too.
Who got Jones?
I got you.
No. One you got, Jones.
I don't know. I'm like, I have it. Yeah.
Thank you, sir. And then you're gonna give it to the approach here.
I'm calling Mark Dow.
Thank you.
I'm calling Mark Dow.
Okay. Oh, okay.
Mr. Pierce just went outside on that.
Yeah, the prosecutor just stepped outside for me to see if the OIC is here.
She's
Something
here.
like that.
Let me handle Jefferson.
Okay.
James Boston, Mr. Dawes, you want to take the?
Sure.
You want to stay up there to take?
Yeah. Oh, okay, right here, Mr. Thank you.
Okay, so People of State of Michigan versus Darnell Allen. Case 21061047. Mr. Allen charged with police officer assaulting, resisting, and obstructing causing injury. 21061801. Possession of weapon in jail. 22060743. Stolen property, receiving and selling motor vehicle. Set on the docket not tomorrow, June 30th, for exams at 11:30. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Thomas C. Jefferson on behalf of Darnell Allen on all three matters. And I waive his appearance. He's in Macomb County Jail, I believe.
Okay, I will waive his presence. What's going on with this case, Attorney Jefferson?
Your Honor, I can't even think of it. Danielle,
Parents.
yeah, she discovered that there was a competency request, I think back in December, and report was never done.
Do you have any information about a referral? Because I don't in the file on any of.
I don't have any information, Your Honor. Like I told, I don't have any information about referral, but I guess her research of the matter, she did discover that someone did request a competency, I believe was back in December, for Mr. Allen. So I am at this point then I am in agreement with a referral being done because whatever was happening back then, and I know the report was never generated, so I am asking for a competency and criminal responsibility be referred for.
Okay.
Or re-referred.
Whichever the case may be. I don't have any documentation of it, but I want to make sure, now I know what's going on. I want to make sure you were aware whether, or I want to know if you knew of a referral, but I will.
I didn't, Your Honor, but hey, whatever he was doing.
Okay, so I will refer him for competency. Let's do 90 days because right now 60 is not, I mean, they're not ready in 60 days.
Right, 90 days.
Okay, we get a date. How about September 19th? That's a Tuesday.
Okay, that works, Judge.
All right, at 9 o'clock.
Okay, I just have one other matter.
Sure.
On Ms. Diamond Jenkins from Tuesday.
Okay, Ms. Parrish, you want to put your appearance on to, we have a referral date for Darnell Allen. Something else?
No, I just, Your Honor, I just want to put on the record, I don't, and I apologize, I'm jumping in, and I don't know if this was already covered, so please cut me off if it was. But I did reach out to MVHS, excuse me, and they explained this to defense counsel that the defendant had a March 23rd evaluation, which he didn't show. It is possible he could have been incarcerated at that time. We don't know. We don't have information on that. We do need to put in a new order today. They asked for a new order on all three cases. So I don't know if that was put on the record, if defense counsel could, it's essentially just starting over, so we need to.
We're referring.
Okay, so I will do on my part as well, and they will try to fast track it for us. I will send them the response, and I'll send you both yourself and defense counsel on it, so that hopefully they can, as I said, fast track it.
Okay.
Okay, thank you, Your Honor. And if I could just have a few more minutes of the court to address Ms. Jenkins, Diamond Jenkins from Tuesday.
Yes.
We were here in the court, I believe, lifted her restrictions, her tether restrictions as far as Pontiac. Her only restriction was she could not come to Detroit unless she was meeting with me, which had to be arranged in advance to discuss her case.
Or for court.
I'm sorry.
Hold on.
for Diamond Jenkins, the exam that was up on the 13th.
Yeah, it was only to Detroit to visit you and for court. So that was a change from the tether unit.
Right. They don't have the order they're saying.
Okay, I'll make sure it's sent over again.
Okay, and it's, but as far as Pontiac, there is no restriction. Is that correct, Judge?
That's correct.
And I know Wall Lake is near Pontiac or in Pontiac, I'm not certain.
I'm not either.
But that is not a restriction for there either, is there?
No,
Okay, thank you, Judge. Thank you so much. Do you guys have the fax number? Or do you need it?
no, we have, Madam Clerk sent the email right over to them.
Okay, thank you. Thank you so much.
You're welcome. Have a good weekend.
Okay, have a good holiday weekend. Bye.
Bye. Thank you. Okay, that's all. Trash. Ready on dial? Ready. 2261088 people of the state of Michigan versus Mark Christopher Dahl, charged with one count of police officer assaulting, resisting, and obstructing with habitual offender second offense notice set for exam. Today, appearance.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Vivi Young, 44626, appearing on behalf of Mr. Mark Christopher Dahl, who is present and standing to my right. Sir, would you state your name for the judge, please?
Mark Christopher Dahl.
And the defense is ready to proceed.
How about people?
People are ready as well. And, Your Honor, there was a little bit of a delay. People just want to put on the record that there was an order for digital, but I spoke to the officer in charge, and the officers, they were undercover, therefore they had no digital, and that's why there was no digital that was given to us or provided.
Okay, this is a miscommunication. I have read that this was an adjournment or dismissal on this case.
I'm sorry?
I have on the file that it's an adjournment or dismissal. That's why I called this out of order.
Yes, and Your Honor, because initially I thought it would be an adjournment or a dismissal. I just momentarily defenses decided to move forward. So,
And Judge, just for the record, on June 6th of 2023, the court did enter an order requiring Wayne County Sheriff's Department to provide to me, as counsel for the defendant, through the Wayne County Prosecutor's Office, a copy of their dash cam and body worn camera video recordings regarding this incident. I'm told now that because they were undercover, apparently they didn't have any, alleging that they didn't have any body cam video recording on. I would inquire as to the dash cam video in the vehicle, whether it was operative at the time. Because if it was not, if it was, and they have not provided it, then I would be moving for dismissal because they failed to obey the court's order regarding discovery.
Your Honor, if I may, I have the officer in charge who can answer the inquiry in regards to dash cam. This is Corporal Robert Landrum. Corporal, you mind to just step counsel over here. State your name for the record, please.
Corporal Robert Lynn.
Mr. Don?
Corporal,
Do what?
Face the judge.
Oh, sorry.
Corporal, if you could please, defense is inquiring. I know you gave us reasoning for the body worn camera, and your office is not having any body worn camera, but defense has inquired in regards to dash cam.
We, my unit, I'm sorry, the unit that we're in, we're riding, you see there, undercover vehicles, there are no dash cams on the current cars.
Very well, Your Honor. Defense is ready to proceed with their examination whenever the court recalls the case.
I will recall it, I didn't know it was going to be a whole. Attorney Mezzi, 10 o'clock is that. Go first.
Thank
My
you, Your Honor.
apologies, Your Honor.
This way, Mr. Don. They're gonna recall it.
What's that?
They're gonna call it back in a few minutes.
Oh.
Our first vote at 11:05.
I'm sorry. You're not mad because I was supposed to.
Everybody.
You know, you can stand right here for a moment. Not yet. I got to call the case.
Mr. Jones?
I'm fine, how are you? Okay, it's 2357045,
People of the state of Michigan versus Gregory Deshaun Jones. Mr. Jones is charged count 1, weapons carrying concealed, count 2, weapons firearm possession by felon, count 3, weapons felony firearm with an additional offensive force offense notice set for an exam date.
Alexander Sugar on behalf of the vehicle P86282.
Good morning, Your Honor. Romy Messi, P68245 on behalf of Mr. Jones. He's present for preliminary exam.
Jones, state your full name for the record, please.
Gregory Deshaun Jones.
Hey, everybody ready to move forward, proceed?
Yes, Your Honor.
Yes, sir.
Any preliminary matters under the judicial sequestration order?
Yes, Your Honor. This time, the people have moved to admit pursuant to MCL 7661131B. Certified copy of defendant's previous felony charge of cultivation, 2nd Street.
And Attorney Mezzi, have you had an opportunity to review that?
I have, and we'll stipulate to
Okay,
for purpose of exam.
okay. It'll be people's exhibit number 1, anything else?
Nothing further.
Nothing for the question.
Okay. If there's anyone on YouTube or Zoom who may be a witness or may testify on this case, now's your time to log off. Same in the courtroom. If there's anyone who's a witness or may testify, now's your time to leave the courtroom. Mr. Kirkpatrick, call your first.
At this time, the people call Officer Jovara Gatias. And Your Honor, may I approach?
Yes.
Mr. Tyus, step up to the court reporter and say and spell your first and last name.
Officer. Officer Joe Parker Tights. J-O-P-A-R-K-A. Last name Tights, T. Yes, ma'am.
Front right there. Make sure you speak up in the microphone. Whenever you're ready, Mr. Kirkpatrick.
Good morning. Could you please restate your name for the record?
Officer Joe Parker Tights.
And are you currently employed, and if so, in what capacity?
Yes, currently employed with the Church Police Department.
And how long have you been employed as a police officer?
7 years.
And were you employed as a police officer on May 23rd, 2023?
Yes,
Did you in fact work on that date?
yes,
Were you by yourself or with a partner?
with the partner.
What is your partner's name?
Police Officer Leo Rozier.
And did your duties as a police officer take you to an area at or near 18810 Houses Street?
Yes.
Is that in the city of Detroit, county of Wayne?
Yes, sir.
And what brought you to that area?
Just routine patrolling?
Did anything happen while you were on this routine patrol?
Yes.
And what was that?
We observed a vehicle that was traveling the wrong way on the one-way street.
Is that a civil infraction?
Yes.
And what did you do upon seeing the vehicle travel the wrong way on a one-way street?
We initiated a traffic stop to the vehicle.
Were you able to conduct that traffic stop?
Yes.
What happened during this traffic stop?
The vehicle was like about 2 times with the driver, which is the defendant sitting there right now. Upon the traffic stop, the driver had told us that he did not have any identification on him.
And just to clarify, when you say the driver, is there anybody in the courtroom present today that you came into contact with on that tape?
Yes.
Could you please point out the individual and identify article of clothing that you're wearing?
Yes, it's a young gentleman right here with the plaid shirt on, the white shoes, in the defense pit.
The record reflect the identification of the defendant? And when you made contact with the defendants, what happened?
I asked the defendant if he had any identification. The defendant said no, he doesn't, which the defendant was placed under arrest for not having a valid driver's license at the time.
Was he asked to step out of the vehicle?
Yes, he was.
And then what happened?
Due to the vehicle was going to be towed, we conducted an inventory search of the vehicle, which we did, which I was able to recover one firearm.
And you conducted the inventory search?
Yes.
And you said you made a recovery. Can you describe what you recovered?
I have to go to my report regulation, but it was a handgun.
And where was this handgun recovered?
In between the seat, the driver's seat and the center console.
Would this have been within the reach of the defendants?
Yes,
And how many occupants were in the vehicle?
there were 2 occupants.
Where was the other occupant of the vehicle?
That was the front seat passenger.
And what did you do upon recovering the?
We did make a recovery safe. I'm sorry, they make a firearm safe, as well as inform the defendant that he will be placed under arrest for CCW. And I did ask him if he had a CPO, but he said no.
The defendant said no.
Yeah, he said no.
And did you issue any citations during this traffic stop?
Yes, he was issued a citation for going wrong in one-way street, as well as the no license.
And was the weapon placed into evidence?
Yes, it was placed on evidence.
Do you recall the evidence tag number?
No, I have to look at already.
We're reviewing your report, refresh your recollection.
Yes.
Your Honor, may I approach?
Yes. You said he was cited for a wrong run on the one-way and on the license.
Yes, the evidence tag number will be 697-129-1.
I have no further questions, Your Honor.
Thank you, Aaron. Good morning, Officer Titus.
Good morning.
So, can you tell me approximately what time you stopped my client's vehicle on June 23rd? Do you remember?
No, I have to look at the paperwork.
Was it during the day?
What was on the videos?
Would it assist in your recollection if you reviewed the police report?
Good.
Yes.
So maybe a copy of the police report here. Can you tell me about what time of day?
Just 1700.
1700, and what is that in civilian time?
5 o'clock.
5 o'clock, so it was around 5 o'clock during the day, correct?
Correct.
And you indicated you were with your partner at the time, Officer Rozier?
Yes.
Okay. Were you the driver of the scout car?
Yes.
And you first spotted this car. Can you describe the vehicle? Do you remember the vehicle?
I have to report, but I know it was an SUV. But
It was an SUV. You recall it was a 2015 Chevy Traverse?
I was a report.
Okay. That would help your recollection?
Yes.
Can I approach, Judge?
Yeah.
So this is 2015 Chevy Traverse.
Okay, that was the vehicle you remember stopping?
Yes.
Officer, you indicated you were doing routine patrol, correct?
Yes.
Are you with, which precinct?
11th precinct.
11th precinct, okay. And then when you saw the Chevy Traverse, you were directly behind it, correct?
No.
Okay. At what point did you get behind it?
As the car proceeded on what's going on, whatever the cross street was. Is
Okay. And that crosser, is that when it made a turn there?
that when I made a turn?
No. Is the cross street, the one-way street that it made a turn on, or before that street?
So the street he was proceeding on, that was on West Mountain,
Okay.
that's where we crossed and met each other. So he proceeded to go West Mountain on that street. And once we turned, got behind him, that's when he had turned on the wrong street. That's the next, directly next block over.
And so he turned on Hassey Street,
Correct.
right there? And this was, so he went in the wrong direction on Cook Street, correct?
Went the wrong way on the wrong street.
Correct, okay. And had he pulled into a house or anything you recall?
Yeah, it was the driveway.
Okay, pulled into the driveway.
Correct.
So based on your investigation, obviously going to the house, correct?
I didn't say that.
Okay. Did you learn that that's where he was going?
Can't recall that either.
Okay. When he pulled in the driveway, is that when your car pulled up and basically initiated the stop?
We went driveway together, that's when we didn't stop.
You did not initiate the stop, he stopped, is that correct? Did you, when he made that wrong way turn,
That's when we got directly behind him, or next stop.
did you turn on your police, the scout car lights?
Turned as soon as we got behind him, so we got close to the stop.
And then at some point, after you did that, you and Officer Rozier both approached the vehicle, is that correct?
Correct.
Okay, on both sides, on the driver's side and the passenger side, correct? And did you see anything in plain sight, looking into the vehicle when you approached the vehicle?
No.
Okay. In terms of contraband or weapons or anything? Do you know if Officer Rozier saw anything from plain sight?
I'm testifying to Officer Rozier.
Did he ever, that's fair. Did you ask the driver you're indicating is Gregory Jones, is that correct? Okay. And did you ask the driver, Mr. Jones, what did you ask him? He had his license on?
Correct.
Okay, he indicated he didn't?
He didn't get on identification. Correct.
Okay. And then you had him step out, and that's when you proceed to arrest him for not having, license on, right?
Correct.
Okay. When you had him come out, is that, did you then have him, go back to the scout car? Did you put him in cuffs and send him over to the scout car?
Yeah, as soon as my partner, Officer Rozier, when she stood in front of the stop.
Okay. So Officer Rozier took Mr. Jones?
Yes.
Okay. And then you proceed to an inventory search of the vehicle?
Correct.
All right. And when you were doing the inventory search, first of all, besides Mr. Gregory Jones, the passenger in this vehicle was Mr. Carlos Polk. Do you remember that?
Yes.
Okay. And he was sitting front seat passenger, correct?
Mhm.
Okay. And was he arrested by you?
I personally,
Okay. Was he asked to?
I personally.
I didn't hear you.
I didn't place him in
Oh, you
custody.
didn't place him in custody, thank you.
Was he asked to come out of the vehicle?
Yes.
By you or by Officer Rozier?
Officer Rozier.
And was he placed in handcuffs? And do you know if you spoke to Mr. Polk, the passenger?
Probably did.
Do you remember if you asked him if he had a gun or anything like
No, I remember asking.
that? You conducted the inventory search immediately after having Mr. Jones out of the car, is that correct? Almost immediately after?
Almost.
And then you searched what areas of the car?
Pretty much his wingspan cover. Before I even got directly into the whole her, pretty much his whole wingspan, it was just his wingspan area.
Where did you start your search?
On the driver's side, building.
The driver's side, rear or front?
Front.
So search in the front, and is that when you located the handgun?
Correct.
Okay. Where was that handgun located again?
On the driver's side, in between seat, in between center console.
Okay. So it was between the seat and between the center console, correct?
Correct.
Okay. Would it be the first thing to say that the passenger sitting in there had access to that front compartment of that car just as easily as the driver?
Good, possible.
Okay. Did you have occasion to speak to Mr. Jones?
Or as well.
Did you ask him any questions after?
Yeah, actually, we have CPL, but she said no.
Okay. He said he did not have CPL, correct? Did you ask if this was his gun?
Nope.
You never asked if this was his gun? You were interested in that?
It's in his possession, vehicles in his possession.
And I didn't ask you that, Officer Tyus, I didn't ask you the question, whether it's in possession. That's a judgment from the judge. The question is, did you ask him if it was his gun?
No, I didn't ask him if it was his gun.
Do you know if Officer Rozier asked him the question?
No, I did not.
Have you had prior contact with Mr. Jones?
Not that I recall.
Okay. You don't remember ever stopping him prior? Okay. Did Mr. Jones tell you that they were also dropping off another individual sitting in the back seat?
There wasn't one anywhere, see.
There was not anybody. Did he tell you there was somebody that was right in the back seat?
I don't recall that. I do not recall.
Did you take a written statement from Mr.
No.
Jones? Was that the detective, the
Yes.
NYC? That was detective,
Yes.
Who is that?
Please, check for seat.
Do you recall asking Mr. Polk if this was his gun?
No.
Of course, in this early stage, you don't know if there are any fingerprints taken on the gun. You don't know if it's been sent in a forensic laboratory?
No.
Okay. Do you recall Mr. Jones protesting the entire time during this arrest that this was not his gun?
Mhm.
He never saw the gun.
Yes.
He said that, correct?
Yes.
Okay. He dropped off a dude. It was somebody else's gun. Do you remember saying that?
I remember saying it was somebody else's gun. I do remember saying it wasn't his gun.
Okay. I have nothing further.
You said nothing. You have witnesses?
No witnesses for the people.
Is the fifth witnesses?
Oh, yeah.
Okay, with, Officer Tyus goes out, and argument is dismissed.
And this time the vehicle was moved to hand over the defendant on count 1, weapons carrying concealed, count 2, weapons firearm, possession by a felon, and count 3, weapons, felony firearm. As we heard from Officer Tyus, officers observed a 2015 blue Chevy Traverse traveled the wrong way down a one-way street. At this point, officers got behind the vehicle as it pulled into a driveway and conducted a traffic stop. On approaching the defendant, who was in the driver's seat of the vehicle, Officer Tyus asked for his information. The defendant was unable to provide his identification at this time, at which time Officer Tyus asked the defendant to step out of the vehicle and he was placed under arrest. Ms. Carter then asked the front seat passenger to also step out of the vehicle so that an inventory search could be conducted of the vehicle since based on the arrest, it was going to be towed. On Officer Tyus searching the vehicle, he recovered a firearm, which he testified was located in between the driver's seat and the center console of the vehicle. As he testified, this was within the wingspan reach of the defendant when he was in the driver's seat. The defendant was then placed under arrest for carrying concealed. He was asked if he had a CPL, which he said he did not. He was also issued citation for driving down the wrong way down a one-way street and for failing to provide identification. Driving a vehicle. Weapon was then placed into evidence. People believe that there's a burden of probable cause and moved to find over to the Third Circuit.
Thank you, Your Honor. Your Honor, the probable cause is a standard I understand it's a lower standard beyond reasonable, but it's a standard nonetheless. That people have to prove by probable cause that my client carried the gun, for count one, carried a concealed weapon, that he possessed the firearm with respect to count two, and that he possessed the firearm with respect to count three. You know, we have a situation here where my client stopped. There are at least two individuals in the vehicle. My client indicated there was a third individual that he told the officer was in the vehicle, in the rear seat that they dropped off. All of these individuals had ready access to the area of the vehicle. The officer found, testified that he found the gun, which was between between the center console and the driver's seat. I mean, yes, we're talking wingspan here, but we're also talking the wingspan of the front seat passenger. We're also talking the wingspan of the individual who had been dropped off, was sitting in the rear seat of this vehicle. There's been no evidence that my client carried this gun, that he touched this gun, that he knew even that the gun was there. There's been no evidence that has been presented by the people to show that. Now, obviously, the argument here is this constructive possession, but we also need evidence of constructive. The fact that I'm in a room and in that room there's a gun doesn't mean that I constructively possess that gun. If I walked into this courtroom, Judge, and there's a gun sitting in that seat next to me, and I'm sitting here, am I in constructive possession of that gun? I don't think so. I think the people have to show more than that in a situation where we have at least 2 or 3 individuals with ready access to that compartment of that car to say that my client, just because he's driving the car, should be arrested and it's his gun and he's tagged with the gun. The fact of the matter is nobody saw him with the gun. He did not possess the gun physically. He did not have the gun in his hand. He had no idea the gun was there. And there's been no evidence to show any of that. So I think there's been a dearth of evidence with respect to probable cause, with respect to carrying concealed weapon or possession of this handgun. And I ask the court to dismiss this case, all 3 counts.
Your Honor, I believe there is a question of fact as to whether the defendant exercised dominion and control over the firearm and whether the defendant had knowledge of the firearm in the vehicle. The defendant was the driver of the vehicle. This weapon was located between the driver's seat and the center console of the vehicle. They also testified it was within the reach of the defendant while he was driving that vehicle. So we would still ask to find over this.
Okay, I do believe it's a question of fact. The trying fact sheet, the issue defense counsel raised is knowledge as far as when it comes to constructive possession. You can be inferred from the testimony that the defendant did have knowledge as the gun was found between the driver's seat and the center console, not between the passenger seat console. Center console was between the driver's seat and the center console. Officer Tyus stated that they stopped based on the defendant driving the wrong way, one way, initiated stop with his light. Asked the defendant if he had a license, the defendant said no. Officer Tyus then had the defendant step out based off of operating a vehicle without a driver's license. Officer Tyus stated that he intended the vehicle to be towed, conducted an inventory search, and found that gun between the driver's seat and the center console. Probable cause that I think there is sufficient evidence to have the defendant found over. So for count 1, people have satisfied that count. And of course, with exhibit 1, that means count 2 be found over as well as the accompanying felony firearm for count 3. Mr. Jones, you will be bound over to 3rd Circuit Court, Frankfurt Hall of Justice for an arraignment on the information date of June 30th at 9:05 a.m. I do not know if you'll be in person or if you'll be on Zoom based off the judge. Right? Body strategic versus computer.
Have a good holiday.
You're all set, Mr. Jones.
picks or?
This one is yours, right, Mr. Kirk?
This one, yes. This one.
You know how many witnesses you have?
Pardon?
How many witnesses have we
Just
called?
one.
You can stand up, sir. Right? Stand up.
Everybody ready on Mr. Love?
Ready, right?
Mr. Kirk, are you ready? Need a moment?
I'm ready, Your Honor.
This is case 2356209, the people of the state of Michigan versus Levon Treville Love, charged with one kind of weapons carrying concealed set, for example, the appearances.
Alexander Kirker, on behalf of the people, PE 6282.
Good morning, Your Honor. Good morning to your staff. Please file report Sheriff Harris, P72832 on behalf of Mr. Love. Mr. Love, please state your name for the record.
Levon Travail Love.
Good morning. Everyone ready to move forward with the exam?
Ready, Your Honor.
People are ready, Your Honor.
Okay, any preliminary matters other than individual sequestration?
None from the people.
Nothing, Your Honor.
Okay, does anyone on YouTube or Zoom who the witness on this case and they testified? Now time for you to log off, stay in the courtroom. If there's anyone who was a witness and they testify in this case, now the time to take the courtroom. You can call your witness. Perfect.
Your Honor, at this time, the people call Officer Chadwick Hopkins.
Step up to the court reporter
How
and
you doing?
say and spell your first and last name. Court reporter.
First and last.
Chadwick Hopkins, CHA, WICK, last name, PK,
That's what we're ready for. Tell the truth, no truth, nothing but the truth.
Yes, ma'am.
We're holding right in front, just make sure you get the right. Right, Mr. Kirk?
Good morning. Could you please restate your name for the record?
Chadwick Hopkins,
And are you currently employed, and if so, in what capacity?
Detroit Police Department, second precinct,
And how long have you been employed with the Detroit Police Department?
3 years.
And were you employed as a police officer on March 30th, 2023?
Yes,
Did you in fact work on that date?
yes,
Were you by yourself or with a partner?
partner,
What is your partner's name?
Officer Duncan,
And were you on foot patrol or in a scout car?
in the scout car,
Was it a fully marked or semi-marked scout car?
fully marked.
And did your duties as a police officer take you to an area at or near Dexter Ave?
Yes,
Is that in the city of Detroit, County of Wayne?
yes.
And what brought you to that area?
It was a restore order in the 10th precinct, just patrolling the area.
And did anything happen while you were on this patrol?
Yes,
And what was that?
I encountered Mr. Love.
And when you say Mr. Love, is there anybody in the courtroom present today that you came into contact with on that date?
Yes, sir.
Could you please point out the individual and identify the article of clothing they were wearing?
A white button up.
Your Honor, let the record reflect the identification of the defendants. So reflected. And what happens when you came into contact with the defendants?
Driving my scout car, observed Mr. Love. Got a black bubble cut on, standing in front of the store. It appeared that he had a firearm in his right jacket pocket.
And when you said it appeared that he had a firearm, what led you to that belief?
The right pocket was laid down. It was an L-shaped object that I readily identified as a firearm from prior experience.
And based on these observations, what did you do?
When I observed him, he turned away from me. I pulled up to him. I asked him, did he have a CPL? He stated, I ain't do nothing. And then he clutched his hand over his right jacket pocket
And was there
And he bladed his
anything,
body away from me.
in your experience, was there anything significant about the motion of clutching?
Yes, through prior experience, he gave me reasonable suspicion that he had a firearm. He clutched his right hand over his jacket pocket.
Was this the area in which you observed the L-shaped heavy-weighted object?
Yes,
So upon making this observation, what did you do?
after I made that observation, he bladed his body away from me, going away from me.
What do you mean by bladed?
Like, he turned away from me from my scout car direction. He was facing me, then he turned towards the store. He bladed his body, tried to walk back into the store, but I hopped out.
Is there anything significant about that motion in your experience?
Most of the time, nervously moving away from the police, just facing our direction.
And what is significant about that?
When he clutched his hand over his right jacket pocket, it gave me suspicion that he had a firearm.
And so you said you exited your scout car?
Yes,
Did you approach the defendant?
yes.
And what did you do upon approaching the defendant?
When I approached him, I asked him, did he have a CPO? And then I grabbed his right jacket pocket and I felt the handgun.
And was this through the jacket pocket?
Yes,
And you said you felt was it immediately apparent that it was a handgun?
yes, I believe so, yes.
And what did you do upon feeling that it was a firearm?
I told him to put his hands up, don't move his hands. My partner helped me detain him. And I recovered the firearm, a black Taurus. So,
And where did you recover this firearm from?
out his right jacket pocket where I believe that it was the first time.
And could you, I think you started describing, could you describe the firearm?
It was a black Taurus. I could refer to my report, but it was stolen per lien.
Did you conduct any further investigation through Liam?
Yes, the gun was stolen. Yeah, and if he had a CPO also.
And did the defendant have a CPO?
It was discovered that he did not have a CPO, and he stated that he was caught.
He stated that what?
That he had been caught
He had been caught.
when we detained him.
And was the weapon placed into evidence?
Yes,
Do you recall the evidence tag number?
yes, I have it in my report. If you'd like to refer to it.
Would reviewing your report refresh your recollection?
Yes. Well, the evidence tag number,
Yes.
it's gonna be 693-666-1. The description of it is gonna be a Taurus G3C, black in color, serial number, Adam Charlie King, 391270. It was loaded with a half-full magazine.
I have no further questions.
Ross,
Officer Hopkins, how are you?
Good morning, how you doing?
I'm okay, just a few questions. Were you the driver?
No,
You're the passenger.
yes, ma'am,
And when you say you encountered Mr. You just seen him?
yes.
So what is he doing when you see him?
Pardon?
What is he doing when you see him? Okay. What was he doing when you saw him?
Standing in front of the store?
Just standing.
Yes.
Do you see him with anyone else?
No,
And you say you see something way down his pocket.
his right front pocket, yes, ma'am,
Could have fallen way down your front right pocket?
possible.
So without touching it, you wouldn't have known that it was a gun?
Ma'am, it was an L-shaped
No,
bird.
this is a yes or no question. Without touching it, would you have known if it was a gun or not?
I believe that it was a firearm.
Yes or no?
Yes.
Yes or no? Without touching it, would you have known if it was a gun or
No,
not? No.
I believe.
It's a no, it's a no.
No,
No.
but it was an L-shaped bulge.
It was a, your answer to my
So a
question
firearm.
is a
Right.
no.
All right. No,
Okay. So see someone on the street, and you just see something in their pocket. You go up to Mr. Love,
mhm.
and you reach into his pocket,
I
like
didn't-
feel his pocket.
I didn't just reach into his pocket. It was the reasonable suspicion of making me believe that it was a firearm when he did. When he turned away from me, and he clutched his right hand over his jacket pocket, I believe that it was a firearm.
Okay.
Yes, ma'am.
So you believed it was a firearm.
Yes.
You approached Mr. Love.
Yes, and I asked him, did he have a CPO?
We just gonna take it step by step, if that's okay with you.
Yes, ma'am.
Okay. So you think it's a firearm, you approach Mr. Love,
Yes,
you feel his pocket,
yes,
and I just wanna be clear, he was doing nothing, he was just standing.
it's not that he was just doing nothing. He gave me reasonable suspicion that he had a firearm.
My question to you, when you observed him,
Yes, ma'am.
what was he doing?
Standing in front of the store.
So he's just standing in
Right.
front of the store.
Right.
Is he talking to anyone?
No,
Is he smoking a cigarette by chance?
I don't recall.
So he's not walking, he's just standing.
Standing in front of the store. Yes, ma'am.
So at some point you put him in handcuffs, correct?
My partner did.
Your partner did. Do you know if he was given his Miranda rights?
I don't believe so. I don't recall.
When he was transported to DDC, was he taken straight from this scene to the DDC?
Yes, I believe so. Yep.
Any stops?
No, not that I recall.
You don't recall any stops along the way?
To the Detroit Detention Center, I don't recall. No, I don't remember.
Is it I don't remember or there are no stops?
I don't recall. I don't recall, honestly.
If we were to play your body camera footage, would that help refresh your recollection bit?
Yes,
And you were wearing your body cam that day?
yes, ma'am.
It was fully activated, it was on during this encounter?
Yes, appears to be.
And you know that it would show everything?
Yes,
And as far as you know, in the state of Michigan, are people allowed to openly carry?
yes,
And as far as you know, in the state of Michigan, people are allowed to carry concealed weapons.
yes, for the CPO.
People are allowed to carry concealed weapons. Is that
Yes.
true? And but for you approaching someone and asking, you wouldn't know if they have a CPO or not.
Yeah.
Is it your custom and your practice to always approach folks who you think might have a gun on their person?
Say the question again?
Is it your custom to approach anyone that you see that you believe they have a gun?
Yes, ma'am. CPO or not?
Your Honor, would the court allow us to play this Officer Hopkins body camera footage?
To refresh his recollection.
Yes, ma'am.
the secondary home. You don't have to, I just, was the clerk prefer that, Hopkins just watches it, or could we only do the report to view it? Refreshing his recollection, I love it. May I approach the witness? Sure. If you want to enter it, then publish it, that's also, I mean, if you go to the steps, that's fine too. Mr. Hopkins, are you okay if I approach you without my mask on? I'd like to ask.
This the beginning, this about to show the whole season. You just watch it.
Can you, say it loud enough so that it's on record what you're asking? So, Officer Hopkins, does viewing that refresh your recollection?
Yes,
Was Mr. Love out there alone?
no, he was a friend, not that I recall.
And just that little clip, I know it doesn't show him being transported to DDC. Now, do you recall if there were any stops along the way?
Yes.
How many?
No, but it was not a stop before I got to him. That guy in the river.
Were there any stops when you were transporting Mr. Love to the DDC?
No, not that I recall.
No further questions.
Nothing further.
All right, thank you.
Any other witnesses or people?
No further witnesses.
Are you ready?
And this time, the people move to bind over the defendant on count one, weapons carrying conceals. As we heard from Officer Hopkins, he observed the defendants with what he saw was a heavy weighted L-shaped objects, which in his experience, he believed at that time, a scout car was a firearm. Upon approaching the defendant in a fully marked scout car, the defendant was observed to turn his body away from officers and to start clutching the right side of his jacket where Officer Hopkins had observed that heavy weighted L-shaped object. Officer Hopkins then exited the scout car and approached the defendant, at which time the defendant started to blade his body away from officers. Again, Officer Hopkins testified that this was something that gave him reasonable suspicion that the defendant was armed, along with his other observations of the heavy-weighted L-shaped object and the defendant's turning his body away from officers. They saw the scout car. The officer then felt through the jacket where the defendant was driving. He then believed he felt was a firearm. The defendant was detained, and Officer Hopkins recovered a 9mm black handgun from the right side of the defendant's jacket, where he had initially observed the heavy-weighted L-shaped object and the defendant grabbing earlier. Then was then asked if he had a CPO, which he said that he did not, and that he was caught. This was then confirmed through me that the defendant did not have a CPO, and the weapon was then placed into evidence. People believe in the probable cause and notified of the third circuit.
Yes. Here, I respectfully, the defense is objecting to the line over as, the defense does not believe that people have met their burden. Yes, Officer Hopkins testified that he saw something in the pocket, but without touching or manipulating that item, he had no idea what it could be, because he himself indicated that without feeling it, he would not have known that it was a gun. This doesn't even amount to a security stop. He didn't have any reasonable suspicion to believe that a crime was taking place. Officer Hopkins even testified that we are a state that allows one, we allow open carry, and two, we allow concealed carry. Reasonable suspicion must be that a crime is being committed, not merely that someone is armed, and we don't know if they're doing so legally or illegally. He had no reason to encounter Mr. Love. He indicates that he's just standing there. Even his testimony is conflicted, which he had to be refreshed to know that it wasn't just Mr. Love standing there. Just standing on a street is not a crime. There's no reasonable suspicion that a crime is being committed. Having anything in my pockets, whether you believe it to be a gun, you believe it to be a phone, that is not a crime. Everything that he did after that was a violation of my client's constitutional rights. He did not have any reasonable suspicion to approach him or to search him, which he did. He didn't Mirandize him or anything. So he had no reasonable suspicion to even encounter his gun, even encounter Mr. Love, to get to the point where he determines that he has a gun. I think that's also justified in United States v. Floyd, which is 2021 WL 2805806. Again, reasonable suspicion must be that a crime is being committed, not merely that someone is armed and we don't know if they're doing so legally or illegally. People have not met their burden. Even when he said he had reasonable suspicion to search, he did. So at this point, we can move for dismissal. Any rebuttal?
Yes, Your Honor. To conduct a Terry stop, which is patting down the outer garments of an individual, officer needs reasonable suspicion that that individual is armed and dangerous. We believe that the officer did have that reasonable suspicion in this case. He first observed the heavy-weighted L-shaped object, which in his experience he testified he believes is consistent with the firearm. Upon the fully marked scout car approaching the defendant, the officer noticed the defendant turn his body away. Again, the officer's experienced something that was also consistent with somebody who was armed. The officer on exiting the vehicle, after making these two observations, officers exited the vehicle and approached the defendant, at which time he began to blade his body away from the officers. All these observations, we believe, did give Officer Hopkins reasonable suspicion that the defendant was armed and dangerous at this point to conduct that pat down of the outer garments of the defendant. At which point, the officer then testified and felt what he believed to be a firearm in the area that he had made these observations. So people do believe that the burden of probable cause was firearm.
Okay, this is a probable cause hearing. I do think that this is a situation or a case in which the articulable facts leading toward reasonable suspicion are minimal, but I do think that it's enough to bind over the third circuit. The testimony from the officer that he observed in the right pocket jacket of the defendant that he waited, it was L-shaped, and that on approaching the defendant clutched his right hand over his jacket and also bladed his body, which is turning his body according to the testimony of the officer. The officer then asked if he had a CPL, the defendant that is, and it said he didn't do anything. And at that point, the Terry frisk was conducted. The officer grabbed his right jacket pocket where he suspected the gun to be, felt a gun in that pocket, and then retrieved that gun based on evidence. For a stop and frisk, the police must have reasonable suspicion that a crime has been, is being, or is about to be committed by the suspect. Police reasonably suspect that the suspect is armed and dangerous. The police may frisk the suspect, meaning that the police will give a quick pat down the suspect's outer clothing. As I said before, the facts are minimal as far as the articulable facts for reasonable suspicion, but I do believe this is up here to bind over the probable cause. We bound over to third circuit court, framework law of justice for the Raymond information dated 2 weeks from today. It'll be June 30th at 9:00 a.m. Okay?
Thank you, Your Honor.
Bodies to be. Okay, we're back on the record on Mark, Chris, and Bernal appearances.
Morning, Your Honor.
Daniela Fairchild, on behalf of the people, P85495.
Good morning again, Your Honor. Reading on 4626, appearing on behalf of Mr. Mark Christopher Dow, who is present, standing to my right, Mr. Dow. Please state your name again to the record, please.
Mark Christopher Dow.
Good morning again.
Your Honor, today was day 10 set forward in first preliminary examination. However, Mr. Dow has decided that he wishes to waive the preliminary examination, but we understand that he will be bound to extend trial on the charges of current charge.
Mr. Dow, is that correct?
Yes.
Any objection from the people?
No objection, Your Honor.
And Mr. Dow will ask you some questions. If you don't understand or if you can't hear me, let me know, okay?
Yes.
So it is your wish to waive your exam, correct?
Yes.
Do you understand you have a statutory right to an exam?
Yes.
So that if you were to demand that exam, you would have to show as a probable cause standard, which is a lower standard in criminal law, but still a standard, that charges I read off earlier on the complaint. I'll read it again, versus 1 count of police officer assaulting, resisting, and obstructing. They would have to show, if you were to hold that exam, that crime was committed in the city of Detroit, and you probably committed that crime. You understand that?
Yes.
And then by waiving your exam today, that means that people do not have to present any evidence as a probable cause. Understood? Okay, that's why I go through this, to make sure. So this is, you're not waiving your right to trial. You understand that?
Yes.
Okay, so this is a probable cause standard. So it's a lower standard where the district court level. So if you waive your exam today, that just means you move forward with your process to arraign on the information date to move forward with trial. You're not giving up your right to trial. You're just skipping over the probable cause here, where the people would have to show minimal evidence, still evidence, but minimal in the probable cause standard. Beyond a reasonable doubt, it's unfavorable to trial.
Okay.
You understand that?
Yes.
Do you have any questions about it?
Oh, no, ma'am.
Okay. So knowing that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have it bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment information on the information date of June 30th at 9:00 a.m. Anything else we require?
Very nice. Continue, please.
Bodies continue.
Thank you. I'll do it again. Likewise.